whether the matter should be listed here or in Nagaland. Then it was sorted out. Now it has been listed, numbered also. Everything is ready. If Lordship is pleased to take up the matter tomorrow, Lordship, there is some urgency. It has been
on Friday.
Friday, Lordship. Not today. Highly obvious. But the problem is sorted out, Lordship, after the application is.
My lord, I'm praying for listing of writ appeal, my lord. In respect of my lord, the order passed in Tanagar bench of this honorable court, my lord. And there is no division bench because my lord Justice Kete has passed the order. So it may be taken up tomorrow, my lord, because urgency.
Have you got the permission?
My lord, already we have submitted before joint session.
Let the permission be granted, then now after that we'll list it.
Then I will mention before your lordship.
Let the registry put up the file.
Already, but application has been.
Application, it has to be approved.
Then I will mention it to my.
After it's approved, it will come up automatically.
I beg to one mention item, my lord, that maybe I want to withdraw it. May I present the item may be listed tomorrow? Because I have to file alternative image and also tomorrow.
May my lord, I beg to mention one writ appeal, my lord. I am holding the charge of the headmaster of a school, my lord. I have been interfered by the Honorable Learned Single Judge, my lord. Some urgency is there, my lord, because the order, my lord, has been lots of discrepancies are there, my lord. Tomorrow or day after tomorrow, my lord.
This is the problem. You know, the last few days, if we don't take up. Friday.
My lord. My lord, another matter, my lord. A PIL has been filed, my lord, regarding the illegal pushback exercise which has been carried out by the state of Assam. Some urgency is there, my lord. Day after tomorrow, my lord. Kindly, my lord.
Let it come after vacation.
No, my lord, what has happened during this vacation, my lord, the certain numbers of persons.
Then it will come up in the vacation bench.
Kindly, my lord, kindly, my lord. Some urgent, otherwise I would not have pressed. I have worked whole night yesterday, my lord, to make the brief ready. Some urgency is there, my lord. Kindly, my lord. It will take just a few minutes, my lord. I will not take much time, my lord. Kindly, my lord. Otherwise, I would not have pressed, my lord.
Yeah.
My lord. And my lord, another repetition regarding challenging the rule, my lord.
That can come up after this.
My lord, my lord. Obligement.
Wait, please, my lord. My lord, an adjournment slip has been circulated, my lord, with respect to item 7 of the daily list, my lord. I seek an adjournment.
Item 7.
Yes, my lord.
Okay, you are 40?
I'm for the applicant.
Okay, on request made by Ms.
Anupadhyay.
Enubadia Leonard, counsel for the applicant. List after summer vacation.
Yes, ma'am. My lord, we fix a date, my lord, first week of August, my lord.
Okay, please the matter on 4th August.
Obligement.
May please, lord. See, I have had a lordship for Impleadment lordship. One has been one has listed today lordship. That one is left lordship on Friday lordship. Okay. Similar Impleadment, similar.
Which item? Which item?
Item 10 lordship.
Item 10.
One left out.
Okay.
Friday lordship.
Then let it come up on Friday. Along with that, we'll list this matter on Friday also. So we'll dispose it out together.
Then today, then after this today matter lordship maybe.
What difference that is make if it comes up on Friday also?
That's why number is not. That's why I have had yesterday.
Friday day after tomorrow.
Let the today matter. Then I
Wait, please, your
I
lordship.
don't understand what I'm saying. Yeah.
Lordship, I pray for listing of a writ appeal tomorrow, lordship. Lordship, we had filed a matter. The order was passed on 18. Lordship, on 20, we had filed the writ appeal, lordship. Somehow, my lord, it was not listed, so we are praying my lord's interpretation. That is in violation of the Supreme Court judgment, lordship. There was a coordinate bench judgment also, lordship, that went against me. So the leave was granted by the single judge to appeal before my lords. Lordship, I pray my lord's intelligence and take it tomorrow, lordship. There is some urgency in the matter, lordship, that is already per income view of the Supreme Court judgment. And that was not referred by the coordinate bench.
We'll have it tomorrow. Tomorrow.
Really, deeply obliged.
Item 1, orders.
Oh.
May I please, your lordship?
You've got the affidavit?
I have filed today, your lordship. We have filed today morning, your lordship. Affidavit in reply, your lordship.
This morning?
Yes, your lordship. Let the matter be come after vacation. your
Okay, MS
And Decca, your lordship.
M. Deka.
And Decca.
N. Deka, learned counsel for the petitioner submits that she has filed an affidavit in reply to the affidavit in opposition filed by the respondents. Huh? Filed by the respondents. Registered to verify, this morning, huh? Registered to verify and place the same on record. List after summer vacation.
Obliged.
2 and 3.
No affidavit has been filed. You have not filed your affidavit.
No, we have not, because I am, they have done it, their part, my part, I have to complete this, so I was a little tied up. So give us a month's time, we will file it.
Okay. Mr. PK Kwasami and the senior counsel. Appearing for the respond number 1 in contempt case within bracket CRL number 1 of is allowed 6 weeks time to file affidavit. Stop. Little. Yeah.
September 11th. September. First, second week.
In item, in this second contempt,
Se-
are you filing any reply?
No, item number 2.
Yes.
We are not responding in lordship.
Yeah. Okay.
Both the matters will come along with that.
Okay, list these matters after 6 weeks.
Content 2 of 25. There is responding number 1, lordship.
Oh,
I have submitted my application.
that we have seen.
Yes, lordship. On last occasion, the petitioners say that they.
No, that's what learned AG is saying, that he is not responding.
But our thing maybe be the first week of September. Time, in the first matter, whatever granted time.
6 weeks. Both these matters will come out after 6 weeks.
Would it be in the first week of September?
I have no objection. Maybe a date may be given on the first week of September,
List the matter on
maybe on 8th of September.
8th of September.
You blow.
Highly obliged.
Item 4.
Lordship, by this I am praying for some more time for compliance of the order, lordship. The pension has to be calculated by the department, so lordship,
Why should we give you 6 weeks?
6 months.
6 months. Why should we give you
They are
6 months?
processing, lordship.
No, see, the learned court, read court. No, this court
Yes.
gave you two months time.
Months time.
That CTC was supplied after 15 days. Correct?
Lordship.
Then why should you take 6 months?
They are some
We'll-
time is
we'll-
granted, lordship. I have stated in my
Grant
petition
them
that
2 months or 3 months, whatever it is. We can grant you 2 months time maximum.
at least lordship 4 months, 6 months may not be. 2 months from today, lordship.
Oh,
Lordship.
how about the other side?
I have soft copy, name is also shown.
Oh, unless we have to hear them also, no? NG could do. NG could do. Let's take up after some time. You just catch hold of that
Lordship.
couldn't do or whatever.
Item 5.
I have no idea about that.
May it please your lordship. I have filed this IA for interim lordship. Lordship petitioner's father's name appears in the voters list of 1966, 70, 85, 97, 2005. Lordship, and her brother's name, who was there as DW2, his name appeared along with the parents in the voters list of 1997, Lordship.
Yes,
And her linked document is the school certificate, and another document is the Kabinnama. Kabinnama was not proved, but the links at the school certificate, Lordship, that also the headmaster did not bring the school records, Lordship. So at this moment, I'll just pray for an interim, Lordship. I have,
Paya,
Yes. My lord, the only link documents your lordship will find page 41, my lord. Page 41, exhibit 1 is details discussed in full, my lord. Why it cannot be accepted.
page
41, my lord.
of the writ petition.
Yes, ma'am. The opinion, my lord. The school certificate was issued in 5/8/2022. And my lord, the person concerned studied in the school in 1992. After, my lord, more than 30 years.
Where's the school
Yes.
certificate?
Yes.
I think that may not be a reason also, Lord.
No.
Later on, a person can take out the certificate.
At page 41, my lord, it is in the judgment itself, opinion of the tribunal. Page 41, page 41.
Page 41.
Yes, page 41, para 1 in the, my lord, exhibit 1 is the school certificate. And my lord, during cross-examination, DW3 reports that he could not bring any records of admission of class 4 of 1992 in the middle portion, my lord. In the school records, mother's name is not mentioned, but written in the certificate as per application of the informant. How can it be inserted, my lord? Record, there is no name. In the certificate, it is included. Even date of birth is also inserted later on. Date of birth was also not there.
He did not bring the record. So whether mother's name is there or not,
Records have come?
Yes.
Lordship, her own brother, her elder brother has adduced evidence as DW2, Lordship. And brother and parents, their name appeared in the voters list of 1997, Lord.
Okay. What the interim?
At this stage, Lordship, I just humbly pray for interim. And then after vacation, it may be fixed for hearing, Lordship.
Third
Yes.
MS in the IA, huh? D. Ghosh Learned Council for the applicants. Also heard Mr. J. Paya. J. Paya, Union of India.
RKD Sudhir's name may be recorded.
No, who was there? The MSP, heard Mr. P.S. Bhattacharya, the CGC for the
Respondent number 1. CGC.
for the respondent number 1. Assam Home Department,
I will appear for Home Department. Respondent number 2.
Mr. J. Payang, then Standing Council Home Department appears for respondents 2.
6 and 7. Also for Malot as Standing Council NRC.
For her.
4, 6, and 7.
2, 4, 6, and
Learned Standing Council Home Department as well as Standing Council NRC appears for 2, 4, 6,
6
and
and
7.
7.
State, Mr. MS.
For for respondent number 5.
Mr.
Respondent number.
You're good, good then. RK Boral, Governor, Phuket, appeals for the respondent number 5. Election Commission
M. Kalita on behalf of P. Board.
and Mr. M. Khalita, Learned Council, appearing on behalf of
P. Board.
P. Barwa, Learned Standing Council, Election Commission of India for the respondent number 3. Bara. Being dissatisfied with the opinion dated 24/4/2024 was by the learned member, Foreigners Tribunal within bracket 2 in case number F.T. Case number 1585/F/60 within bracket arising out of police reference IMDD case number 559/1998. 1998, whereby the tribunal had appointed her to be a foreigner under the Foreigners Act 1946. The petitioner, the appellant as writ petitioner, preferred WBC number 5025 of 2024. Stop. In the said writ petition, records were called for. Stop. Para. By way of the present application, the applicant is praying for an interim protection for a direction to the concerned authorities not to arrest/detain and deport/pushback the applicant during the pendency of WBC number 5025/2024. Stop. Writ petition has been admitted.
Notice it was issued, Lordship, on the last one. On 21/2025, notice was issued.
Okay. As notice has already been issued on 2025. No notice is issued.
27, yes. 27/9.
There's no notice. No notice is there 21/2025.
My lord, may kindly see 27/9, my lord.
Huh?
27/9/24. Order.
In which order? Anyway. As the records have already been received in the said writ petition, the respondents, you'll appear before whom?
But Dhubri, SP border Dhubri, Lordship.
Just put that SP border within bracket 2 Then what you call this alarm knows how to do it. Huh?
Deeply obliged, Lordship.
I can be disposed. No. Yeah. Keep it. In the main petition, records have been issued. List the matter immediately after the summons petition.
Item 6.
Yes, what we can hear it if it is somehow the petition.
Because they have,
The amount has been credited or not?
yes, they have filed an affidavit.
Where?
I have
In the IA?
at page 250. 248 it starts.
248. In the writ petition.
And relevant letter is at page 252.
Oh.
Because instead of that, there is a correction to be made with 19th. They say actually the order is of 18th. That is positive. But they have deposited, and we have received their email also.
Oh, where's the interest? Okay, I have to. Okay, along with interest, Dev,
Yes, along with the interest.
then we can list this after the summer vacation.
After.
Oh.
No?
On request made by the parties, this is the method for after the summer vacation.
Make it Millard in the month of August.
List the matter in the month of August 22. Interim is absolute.
Yes, yes.
Interim is absolute.
Yes.
Okay. No need for
Subject. That is already complied with. That's why your lordship fixed it. Deeply of that.
Item 10, orders.
Yeah. Yes.
My lord, in this case, my lord, like highly, your lordship kindly take up my lord IA my lord 2069.
Which item is this?
My- 2069, my lord.
Oh.
My lord, we had a candidate, my lord, appearing in the interview, and some candidate they are appearing in the interview. After that, my lord, they came before this honorable court, challenging a particular clause of a rule, also challenging the my lord interview. Now, as a result, my lord, yesterday result was declared, but as far as Hindi graduate teachers is concerned, results are not declared because of the pendency of this case. So that's why we are very much interested, my lord. I am included, my lord. In fact, my lord, there is no order from the honorable court, my lord. Simply, my lord,
Where is the
matter of-
order? Where is the order passed by this court? In the writ petition?
that is, my lord, order dated 12/3/2025.
Majumdar, it is only subject to the outcome of this writ petition. You can declare the results.
This will be
So, pendency of a repetition, my lord, will keep that. Usually. Skip. My lord? My lord, that is the practical field situation.
So we.
Once there is a litigation, we do not.
then we-
Say onwards, we'll pass subject to outcome of the case. You don't proceed.
My lord, I am for the writ petition, my lord. My lord, my respected senior friend has filed an impleadment, my lord. So, my lord, let them implead and come up with a proper application, my lord. Direction, my lord. Without impleadment, my lord, they have no right, my lord, to hesitate.
No, now today I want to implement, my lord.
My lord.
Definitely.
That we
But-
do not, my lord.
Object. You don't have an objection.
My objections may be recorded, my lord, allow, my lord. Otherwise, my lord, this is the issue of. My lord,
Majumdar?
No difficulty, my lord.
Heard Mr. T.J. Manda, learned
That is
senior
from
counsel.
3 to 57.
Assisted by Mr. D. Manda, learned counsel for the applicant. Stop. Also heard Mr. A.R. Bhuyan, learned counsel for the opposite parties.
3 to 57.
1 to,
So I may implement party, my lord, 3
no,
to
no, 1 minute. Opposite parties, 1 to 23.
my lord, respondents,
Opposite parties
opposite.
in the IA, huh?
Yes.
1 and 2.
1 and 2, my lord. Only 2 respondents in the writ, my lord.
No, no.
So thereafter, yes, my lord, opposite party 1 and 2, and the rest will be, my lord, implemented from 3 to 57.
No, no.
You are for.
I am for in the I am.
1 and 2. Oh, yes, I.
No, my lord.
I put.
Page 19, page 19.
My lord, my lord.
From 1 to.
Oh, it is on-
It will be up to 23, I think.
Yes, my lord, writ petitioners are, my lord.
1 to 20, yes, 1 to 20.
23 my lord.
For the opposite parties, 1 to 23, and Mr. D. Majumdar, learned Standing Council, School Education Department for the opposite party, respond for the opposite parties, 24 to 25. Stop. The applicants before this court, in the present application are candidates who have appeared in the selection process
Maybe it's called TET cum recruitment test, madam.
for the TET cum
Recruitment test.
recruitment test held on 19/1/2025. Stop. With regard to graduate teacher,
Graduate teacher in respect of Hindi.
Hindi my lord, only.
with regard to graduate teacher within bracket Hindi. Stop. The applicants are applying for implicit in WBC number 1445 of 2024. In as much as the it is the case of the applicants that they have passed the graduate and postgraduate degrees in different subjects, completed PT/B.Ed degree, and passed out all the examinations, and also completed the Praveen/Ratna degree, and therefore are eligible to apply and get appointed in the post of graduate teacher within bracket Hindi as per the secondary education within bracket provincialized schools service rules 2018, and also as per the advertisement dated 27/12/2023. Stop. However, as the opposite parties 1 to 23
My lord, the
had
challenge.
filed WBC number 1392 of 2025. The results of the said examination has not been declared by the official respondents. In that view of the matter, it is the case of the applicants that if they are not allowed to be implemented as party respondents in the instant writ petition, in WBC number 1392 of 2025, the applicants would be seriously prejudiced in the event any order is passed by this court without hearing the stop. Mr. Moyan, learned counsel for the opposite parties 1 to 23 petition. However, submits that the applicants are not necessary parties inasmuch as the petitioners have only challenged the
Policy of the government.
policy of the policy of the government.
Advertisement also second.
Whereas they have not yet selected, their right has not yet been accrued.
But I am appeared, madam.
Majumdar, you have anything to say? After hearing the learned counsel for the parties, where of the consent of that it would be in the interest of justice to implement the applicants as party respondents number
3 to 57.
Huh?
From 3 to 57.
No. Party respondent in the writ petition.
3 to 57 because there are only two official respondents. In prayer, my lord, I have stated.
As party respondent 3 to
57.
57 in WBC number 1392 of 2023. Stop. Accordingly, the prayer for impleadment is allowed. Stop. IS disposed. Sorry. In the writ petition in view of the order passed today in IA number so and so, let so and so be implemented as party respondents. 3 to 57 in the present petition. As Mr. TJ Manda, the senior counsel, assisted by Mr. D. Manda, appears on behalf of the newly implemented respondents, 3 to 57. No formal notice is called for. You want to file affidavit?
Yes, ma'am. I want to file affidavit, but they have to, my lord, they have to
Yeah.
amended course title has to be filed by the petition.
Petitioners are directed to file an amended course title within 1 week. From today, stop. The newly implemented respondents. You filed your affidavit, Majumdar?
No, my lord, only have to file.
As well as the respondents, official respondents are allowed. How much time?
File after vacations.
Allowed 3 weeks time to file their respective affidavits. List after the summer vacation.
Item 8, petition of state.
I think.
So these are the, my lord, partially, my lord, this is, these are the appointments, my lord, under Mission Shakti scheme, my lord.
Yes.
Well, originally, well, as per this, my lord, NGO was the running the show, my lord. And they were appointed by the NGO. The principals, my lord. Now, as per the new scheme, my lord, if your lordships want to see a copy, I'm just giving a copy, my lord. It would be there, my lord, I was going to make a suit. Make it. Yeah, that's very good. It is good.
You have just one copy?
Yes, I'm giving it. Itu back of the place, you come to the Well, actually, as per the scheme, if you'll also see that paragraph, proposal for the new homes from the state is will be considered for financial assistance, no funding support, construction of new homes will be provided, the cost of running such administrative costs, including rental will be provided. Further, all existing homes currently being run and operated by NGO will be permitted to run till 31/3/24, giving sufficient time to the state union territories to get this integrated into new scheme. So they are to integrate, my lord, not that replacement. They are to integrate into the new scheme. No request for action will be made. So we are working under the NGO. We should be integrated, my lord, into a new scheme, my lord, because it is taken over by the, my lord, district authorities. My lord, the committee was constituted in this regard.
And
Where is your appointment order?
my lord, yes. Appointment orders were, my lord, but if you'll also see at page 114. That was there, my lord. But they are working since then, my lord.
Where is your appointment order?
Page 114. That is by the NGO.
Yes.
Yeah, and then thereafter, my lord, these are taken over and we are paid the salary by the this thing, my lord. These are, my lord, if you also see, my lord, our slips are there from page 62 onwards. My lord, earlier also, we are paid the salary.
Page?
Page 62. Page 62, 63, my lord, and owners, my lord.
Which rectifications does commission? Subsequently.
That we may have.
And if any new appointments are to be made, my lord, the committee was formed, my lord, for the selection, that is at page 106.
You are aggrieved by the order, isn't it? At page 158,
Yes, my lord.
157.
167, yes.
This petition is still pending?
My lord, that is pending. That is pending.
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 And then what is this writ appeal 208 of 2025?
Same, my lord. Same. That is also same. It's also. My lord, we are appointed, my lord, thereafter, my lord, they issued notice for termination, my lord. That is that.
Okay.
That is my lord.
So
Now-
it's still pending.
Now, yes, it's still pending. Now, if you also see, my lord, the committee was formed, if any new appointments are to be made, now, if you also see page one, page 106, my lord, if any new appointments are to be made, a committee was formed by the director at page 106. It is not the, my lord, only the district commissioner, but here three persons are there. A district level selection committee has been constituted under the district administration with the following members in connection with the matters relating to recruitment and functioning of one-stop center for the post of multiple works and security guard under the mission against the vacant post. So vacant posts are not there, my lord. We are only working. If any vacant posts are there, that is another aspect of it. Now, it is committee is to my lord here. Here, my lord, what happened? The deputy commissioner has issued an advertisement. District commissioner. That is at page 101. Page 101.
Just a minute.
My lord. That is the advertisement issue. Against which, my lord, we preferred the repression. This was issued by the district commissioner. But in the committee, district commissioner is also not there, my lord. Actually, district commissioner and two others are there. The committee has not issued this advertisement. Yes.
Committee. Where is the provision? The committee has to issue the advertisement.
Yes, my lord. The committee, my lord, and that in the scheme also district level committee is there to form, and accordingly director has formed the committee. The provision is there in the scheme, my lord.
Is this connected with item 11?
Yes, same, my lord.
What is there in item 11? Let us see.
Yes. Same thing, my lord. It
Same thing.
Yes, same. Exactly same. my lord.
Then what is this order?
Yes.
Page
11 to go.
161. It starts from 161. Operative portion is 164, 65.
Very good. That is also, my lord. Not, my lord, that page 143, my lord, the same order. No,
It 161.
No.
161 is it?
Friday the portion will be.
That is, my lord, for our, my lord, single judge has passed an order. So far, termination of this is concerned, we have challenged it. On the ground that, my lord, the deputy commissioner has not the power. It's a, my lord, committee only, my lord, they can do that. And that is why, my lord, this honorable court has passed the order.
Sir, petition to challenge the advertisement, second petition to challenging the termination order.
In the second petition, individually, we have passed, filed the petition challenging their termination order.
Termination order, what, because of the order passed.
1665.
Yes.
In writ petition 1665,
My lord.
the learned writ court
Yes.
did not interfere with the advertisement,
Yes.
but then they said you may be given the 60 days notice.
My lord.
And
my-
then they can post it.
Yes.
Now, after that, what happened?
After
After that, you were terminated.
my lord,
correct.
we are termination notice has been issued,
Notice was
and
given to you. and-
advertisement is there, my lord, and they are going for selection, my lord.
Okay.
That is the, my lord.
Now, another thing is that after that, you challenge your termination order
Yes,
in a WBC number.
my lord. WPC, my lord, several petitions are there, my lord. That is one, WPC 1665 of 25.
176.
1665.
No.
Huh?
No.
Oh, sorry. No, I'm
3484.
3484.
That's total 7 petitions are there.
We have them, it's 27.
Page number 150.
What is 161?
Seven petitions were filed, my lord. That is a common order.
You have filed a WBC number
Several, yes.
during pendency of 1665.
Yes.
You filed 3485, correct?
Yes. Yes,
Challenging the termination order.
my lord.
And in that order,
Interim order was passed.
this court has passed the interim order
Well-
directing not to give effect to the
Well-
termination
lord.
orders. Then what protection do you need more? What
No,
for
my
the-
lord, I'm on the point, my lord, that this 60-day notice itself is, my lord, because this advertisement is wrong. Advertisement, my lord, because it's a scheme, as part of the scheme, it is to be integrated. My lord, if any vacant posts are there, my lord, they can advertise. Now the advertisement has been issued by the deputy commissioner, a district commissioner, who is not the authority, my lord. The selection committee who is to issue the, again, vacant post only.
Where is it provided? Where is it provided that it is only the committee that can
My
issue
lord, page
advertisement
106, page 106.
of the
Of the first petition.
first
petition, my lord.
appeal?
Director has formed a committee.
Implementing agency.
That is the,
My lord, huh?
It is decided once to be decided to the district level committee.
Yet person. Yet person. That is in the scheme, my lord. The district level committee is there, my lord, in the scheme also.
no, this order of director in 106.
Yes.
This is with regard to the district selection committee.
This level. Yes. That is, my lord. They have to publish the, if any vacant post are there. It says
How-
the Mission Secretary against the vacant post.
District level.
How can this committee publish the advertisement?
There is no committee.
My lord, first thing, my lord, a decision will be taken, my lord, by the committee. Then only, my lord, on authority, my lord, as part of the year. And you can also see, my lord, in the scheme, at page 39 of the scheme, district level, my lord, will be there, my lord. Page 39.
Which
39. Three point 2.3. The overall implementation of the scheme at the district level will be done by a committee headed by the district magistrate, district collector. The committee will be serviced by officers in charge of the women and child development. The other members of the committee will be nominated by the BM, GC, drawing officers from the concerned department like education, health, police, skill development, banks, etc. So similar lines as state level committee. The committee also provides annual action plan, block so and so, and the various components of scheme. Confirmation of the grant to any agency would depend on the sanctuary performance as assessed by the district level committee. The committee shall meet at least. Well, my question is only this, my lord. Because district level committee, now here the director has formed a committee. And committee has to take a decision that there are vacant posts are there. Because already we are there, my lord, in the post. And because. Running will be so my question is this, my lord, this advertisement itself is a wrong, my lord.
That matter is seized before the learned tweet court, isn't it?
My lord?
You are challenging the advertisement before the learned tweet
Yes.
court. All right.
Yes,
Now, in 1665,
yes,
the learned single just said, proceed with the advertisement.
yes,
And you will be given 60 days
my lord,
notice.
that is the my lord,
After giving 60 days notice, you are terminated.
my lord,
You challenged that order in 3483.
my lord,
Correct. That order was stayed.
yes,
The termination order was stayed.
my lord.
Now, what more is there? You're protected.
No, my lord, is this,
That issue of advertisement,
yes,
whether it has been done by the appropriate authority, whether they have the right to advertise,
yes.
all this will be considered by the learned single judge.
My lord, this order passed by a single judge by giving 60 days notice, my lord, that order is to be, my lord, stayed, my lord. Because that is my lord,
That part, they've already taken steps. They've issued the 60 days notice.
my lord,
They've terminated you.
correct, my
That termination order is stayed by this court, by the learned single judge. What more do you want?
but that order, till the order remains, my lord, it will affect me. That question.
The subsequent writ petition which you filed challenging the
Right.
termination order. The learned single judge has said that the termination order will not be given effect to.
It's correct, my lord. Only that is.
Now, when the termination order is not given effect to, they cannot make a further appointments also.
Okay, my lord, that is correct, my lord. I'm not, my lord. My question is this, my lord, only, my lord, this direction, my lord, to terminate us, my lord, by giving 20 days notice itself is, my lord.
That has become practically it has become a sort of a network issue because they have already been terminated. By following the direction passed by the learned single judge in 1665, they've issued you 60 days notice and terminated you. Then you came before this court, that termination order is stayed. Now what more? Unless, what do you say?
Only thing, my lord, I want them, the observation of the single judge at 60 days notice, my lord, they should sign that, my lord, that should be. Because that will affect me, my lord. That will.
How?
My lord, because the single judge, as per the single judge's direction, my lord, his notice is. Appointment order condition is, my lord, appointment order condition, my lord, that is NGO. Now it is taken over. Why, my lord, first appointments have been made when I had that.
What my lord was trying to predict. That the termination orders have been fixed thing. How can the appointments? One. Two, you say the posts are not. The government has taken over the whole scheme. Now you have employees of the NGO. If you have any dues, you have to go against the NGO, not the government. They treat the whole post as vacant, and all those issues will be treated, dealt with by the non single judge. That's what my lord is trying to do.
No, it's my other friend is saying that they may also participate, but that was not the question of them. Because now we are already there in that.
I think you should withdraw this writ appeal and contest in the before the is the best thing that we can think of.
I don't actually, my lord, this
Because the first case, in
Yes.
the first case which you filed, 1665, Leonard Single just said proceed with the advertisement.
Yes.
And you may give 60 days notice in terms of the appointment order by the NGO and then take steps. They give 60 days notice. Terminated you.
Nothing, no?
But then in that second writ petition, so advertisement was not interfered with. Only that this the learner single just said is the termination order shall not be given effect to. Now, when you are not terminated, even if the advertisement process, selection process concludes, they cannot issue any appointment order because you are holding the post.
No, it's correct, my lord. On my question, it is, my lord, suppose a contextual or temporary employee. I mean, why they should be substituted by another, my lord? My question is this, my lord, because
No, that is not the issue here. This is something else. This is a scheme.
Yes.
It's up to you.
What 60 days notice was it observation?
Well, let it come day after tomorrow, my lord.
Okay, on request by Mr. Jain Shahingula, let us sing a council for the applicants. List the matter again on 27th. Same order in the item, I, 18, 11, huh? Same order.
Milord, instead of examining the procedural part as to how the impugn order was issued, whether there was any procedural irregularities, illegalities committed, the learned single judge went on merit and comparing two documents held that yes, I am guilty of forgery. Is it permissible? Should it be done? Question is this. In the 226 application, court will definitely consider whether procedural safeguards were provided or not. And if it is found that procedural safeguards were not provided, the very initiative taken, the initial step is vitiated because of certain inaction or illegal action. Then court will not go into the merit. Merit is the last part court is to see if there is anything at all, whether on merit also that could have been said or not. That will be a commercial contract. Kindly see. I was granted a contract to manage a cluster of guest houses. And one of the conditions, eligibility conditions were the experience part. Experience part. Experience to run at least for 3 or 5 years to run such clusters. 3 years. And I submitted one lease deed showing that this property was granted to me on lease and I run it. It is in the page 87. I will take your lordships later on, but I am referring to just giving you the facts. And then I also submitted one license, trade license. Trade license is required to run the business as such. In the trade license, I was shown as a owner, proprietor of the business. And the lease deed, I am the lessee. That was submitted. It was examined by the tender evaluation committee. There is a procedure laid down how to evaluate. Markings were there. Ultimately, they granted me. I went ahead, invested, I was continuing. Same things I submitted for some other contract under the same department. in Kaziranga and another contract there in British. This is also in British. Then in another contract in Kaziranga, that committee, they found it that how come this is, in one I am shown as lessee and the other in I am shown as proprietor. So this itself shows that you have forged the documents. Therefore, they issued this forwarded to the other, to my contract here, and they took the action, holding that you have committed forgery. So cause you have committed forgery, why not you should be punished for forgery? But that there, they express a definite opinion that we are already convinced that you have committed forgery. I am on that first. Whether this amounts to a notice to show cause in its legal consequences. This was my case. This has not been gone into. Kindly come to that notice first. I am taking your lordship to that notice at page 146. Lordship may come to 147. This is the notice issued to me. It is regarding subject is the development, operation and management contract for running the newly constructed Lucky Bazar, Sumbagan, Miapara cluster of Manos National Park. This was the reference.
147.
146. That reference lordship will find at 146. So cause notice they say subject, then thereafter. And then I will take your lordship to 147, paragraph 2. Lordships are on that, my lord, page.
Yeah.
147, paragraph 2. That pursuant to such notice inviting bid, you so-and-so had participated in the tender process, and among all the documents submitted by you, an agreement dated 15/1/2016 was submitted to prove that credentials pertaining to experience in running a registered hotel, guest house, resorts, having restaurants and food and beverage services for minimum 3 years, quote unquote. Such agreement dated 15/1/2016 was shown to have been executed by you with Birida Tourist Lodge. In the said agreement, it has specifically been mentioned that the first party is the absolute owner and possessor of Birida Tourist Lodge. That as per the agreement dated 15/1/16, you are not the owner or proprietor of Birida Tourist Lodge. But another document, that is trade license, submitted by you shows you as the proprietor of Birida Tourist Lodge. Being suspicious, the ATDC wrote an email dated 4/5/2023 to Birida Resort with a request for confirmation that the aforesaid agreement was duly executed. In reply, Birida Resort via email dated 5/5/2023 stated that they have not come in terms with any party for any such. This agreement is unlawful and herewith void. Thus, Birida Resort had confirmed that they had no terms with you, and the agreement dated 15/1/2016 is unlawful and void. That, sorry, you had deliberately submitted forged documents with an intent to deceive and manipulate the tender evaluation process, thereby violating the laws and regulations governing the tender process and compromising the principles of integrity and fair competition. That makes that phase. In this regard, it is further stated that such fraudulent activities come to light during evaluation of present tender process, and on further inquiry, it was revealed that you had earlier submitted the aforementioned agreement dated 15/1/16 in an earlier tender process pertaining to detailed notice inviting bid so-and-so dated 3/8/2022 inviting bids for development, operation and management contract for running the newly constructed Lucky Bazar, Sambagan, Bhuiapara cluster. So here the difference comes they were considering it with regard to the other one. Now they have gone for. Initially at paragraph 1 itself, 146, Lordship will find page.
They've issued a fresh NIT.
They issued fresh NIT. We
When-
came before this honorable court. This honorable court said, don't go ahead, don't finalize. And ultimately they said that though they go ahead, but they have not entered into any contract with them. That was their affidavit.
On affidavit.
On affidavit. They said that no contract has been entered with them respecting the order of this honorable court. That was the situation prevailing. Learned single judge was of the view that the other party ought to have been made a party, so it is for necessary party, it is bad. In my responsible submission, this is also not correct because they were brought in between. Even they are not coming physically. It is not finalized. By order of the court.
Being a tourist was made a party.
And being that tourist laws was made a party here.
Notice was served.
Notice was served.
They did not come.
No response. No response. Another thing, I have been blacklisted personally.
No, they-
They say that I have forced it. They are categorically, they said, well, can you see here at 148? Page 148. Their categorical opinion.
Yes.
Page 148. In the second para, it is needless to mention here that your bid was accepted in the earlier tender process and subsequently you were selected for the contract so and so. That is development, operation and management contract for running the newly constructed Basbari cluster at Manas National Park based on your fulfillment of mandatory eligibility criteria regarding experience in running hotel for 3 years based on the above mentioned document dated so and so, which we not to resolve such eligibility criteria were not fulfilled by you, then you would not have been selected for the contract and the letter of intent dated 8/2/2023 would not have been issued in your favor. And since you had fraudulently submitted void and forged documents to illegally fulfill such criteria, as such the contract awarded to you is liable to be cancelled. So it is their definite opinion. Next, 5, my lord, that the fact and circumstances stated herein above make it crystal clear that you have been running and managing golf properties by submitting forged documents in tender process. My lord, Lordship will kindly appreciate, as the apex court has held already, that in the so-called stage, you are to just level the charges. You cannot hold an opinion, definite opinion. You are to inform the party that why not on these charges action should be taken against. But if they take a firm decision on it, kindly see. This is Oryx Fisheries Private Limited, 2010-13 FCC 427. Let me read from paragraph 26. Kindly see. Paragraph 26. Asar Das, CJ, speaking for the unanimous constitution bench in Khamsand, held that the concept of reasonable opportunity includes various safeguards, and one of them, in the words of the learned Chief Justice, is an opportunity to deny his guilt and establish his innocence, which he can only do if he is told what the charges leveled against him are and the allegations on which such charges are based. 27. It is no doubt true that at the stage of show cause, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at that stage, the authority issuing the charge sheet cannot, instead of telling him the charges, confront him with definite conclusions of his alleged guilt. If that is done, as has been done in the instance case, the entire proceeding initiated by the so-called notice gets vitiated by unfairness and bias, and the subsequent proceedings become an idle ceremony. My case is this. They have expressed definite conclusions. I asked for time to so cause on held ground. My father was not keeping word. They didn't grant me time. They took the decision. Nonetheless, I submitted another application for reconsideration by giving a certificate from that particular authority. That was also not considered and simply took the decision. Therefore, my full submission, here is a case to be examined. There is a case to be examined. Whether learned single judge ought to have looked into these procedural aspects or not. Okay.
Yeah, sure, notice.
May I please, Your Lordship? I am appearing on behalf of Ms. Pallavi Barua for respondent number 225.
Respondent? Okay.
So, if a notice may be issued, and we seek time to seek instructions.
Issue of interim is not allowed. But But Mr. K.K. Mount, Learned Senior Counsel, assisted by Mr. K. Mount, Learned Counsel for the affiliates. Issue notice. Who appears for one? Mr. S. Bora, Learned Governor Advocate, appears for the respond number one, and MS.
L. Bakshi.
And Bhakti, Learned Counsel, appears on behalf of
Ms. P. Barua.
Miss B. Barwa, Learned Standing Counsel.
Not standing counsel.
Learned Counsel.
H for respondent number
Learned
225.
Counsel for the respondents 225.
By finding caveat they are here.
Why filing caveat? Six, you'll have to take steps there. Appellants to take steps for service of notice on the respondent number 6 by registered post AD within 1 week.
Yeah.
1 week. List after 4 weeks.
Meanwhile, Lordship will kindly grant me a protection.
What protection?
Meanwhile, they should not. Stay petition is there, Mala.
No,
They
that,
should not bring in the third party.
no, already there.
No,
Page 196.
196.
The observation in the current single judge's order.
Lordship is referring to Learned Senior Judge's order.
No, 196.
It's a part of an affidavit.
The second last para.
In this regard, the development humbly states that the tender process was completed on manner. When the letter of intent dated so and so, the council also will deposited security and hide deposits so and so. Now they have, well, my assumption, kindly see at page 274. Page 274. 32, para 32.
That's the first affidavit they filed.
And that was the first affidavit they filed.
So then the court wanted to clarify, is it taken over or not? Saying that this affidavit.
The Honorable Court wanted to clarify, know whether they have taken over it or not. Then they submitted this affidavit. 274, para 32. Page 274. It is also pertinent to mention that admittedly the service was not effected upon the respondent still so and so as reflected in the judicial order passed on date as it is also submitted in the affidavit so and so. The order was not within the knowledge of the respondent. There was a contempt petition, my lord. Thus, considering that there is an interim order passed by this honorable court, the respondents with highest regard to this honorable court kept the process of execution of the agreement on hold with the successful party till disposal of the petition. That is the present stage.
About this Mona Lisa communication, they have to be with the party also, isn't it?
They were not brought in as a party because they were subsequently after this process was initiated, this was going on. Then they wanted to say that we have meanwhile gone on and this Mona Lisa was selected. Court wanted to know.
298, like 11 months.
298. Yes, my lord. The council will respond with 225 submitted due to a typographical error or the performance institute. Sorry. As such, as on date, Mona Lisa construction is still running the cluster. It is not correct. It is not correct.
If I may submit your
That is
lordships. So the letter of intent to Mona Lisa Communication was issued on 18th December 2023.
Oh, it was 18 December 2024. The court has noted it. That's right, sir. Lordship has pointed out.
There has been certain
But it have not been brought in.
corrections, your lordship, which are required to be made in this order. So Mona Lisa Communication was awarded the letter of intent on 18th of December 2023 for a period of 5 years. So since we are yet to request the court for some typographical errors which are to be corrected. So if I may submit, so this letter of intent was issued on 18th of December 2023 to Mona Lisa Communication, and the property was duly handed over on 27th of December 2023. And then 18th of December is the same date on which this writ petition was filed. On the date when the letter of intent was issued, firstly. And secondly, your lordship, the information about the stay which was issued in the writ petition by order dated 20 of December by Honorable High Court. This was communicated to respondent number 4 only on 3rd of January.
The next written date. Okay, so do one thing, MS so appears on behalf for this month and press for some time to receive instructions. Then after that, status.
Lordship may.
The prayer for entry shall be considered on the next written.
Meanwhile, because now landed single judge of Sadia order will not be effective. Therefore, interim order was there earlier. Now they may go ahead and hand over because they have already admitted in their affidavit at page 274, as I have shown it, that they have not finalized the things. They may take the plea. Yeah, arguing.
What do you say?
It will create complications.
Okay.
It will create complications.
Other than cancel the order. Parties are directed to maintain status quo as on today.
Well, I respect your lordship's order, but the question is, there is always a scope. Therefore, lordship may clarify that if again, my lord, the if word even created complications in many cases.
That will create.
Therefore,
Let it be status quo as on today.
therefore, my lord,
If nobody is there, nobody is
no,
there.
my lordship say that if they are also there, let them come and clarify. Lordship will for the first time say, referring to the paragraph 32, that since no contract was made, no contract shall be made until further order. That that go on the,
Let it be the status quo.
let that go, my lord. What I am saying, my lord,
This
if
is
they are
not the end
entered,
of the matter, Mr. Moff. We are considering it again. You can always renew your prayer.
my lord,
If that is not there, we will see to that. it
I
is not
humbly
there.
agree with your lordship, my lord, no issue. But then, as on today, the situation, what is remaining, that should be by referring to their own statement. Lordship may say if they have not gone for one, they should not go for any other further contract or anything else.
That gives more scope to them.
And
But then the status quo would be better for you.
well, they may get to say that we are already there. That is why the difficulty. And again, I have to prove it. So that's the status quo. Deeply obliged.
Much obliged.
Keep it in that file.
What is slightly irrelevant? This matter, Lordship, we have recently received the instruction from the registry, Lordship. We need Shantam to
Okay.
file our affidavit. of course.
Okay, heard, Mr.
A Sattar, madam.
K?
A Sattar.
Yes, okay, for the petitioner. Mr.
And case from our Lordship.
N.K. Sharma, you are the standing counsel
No,
now?
I am appearing on
The
behalf of
counsel
the-
appearing on behalf of H.K. Das and the standing counsel Guwahati High Court. Praised for how much time?
After petition, Lordship.
Praised for 3 weeks' time to file counter affidavit. Praise a lot, list after summer vacation. Or less after 3 weeks.
Deeply aware.
13. Yes.
Lordship, which relates to the NOC of a pharmacy college, Lordship. Details,
What is wrong with this order?
Lordship. Wrong is that, Lordship. Sorry, Lordship. Wrong is that, Lordship, the once earlier, by virtue of this honorable court order, they make an inspection on all the inspection reports shows that everything is in order, Lordship. But subsequently, that order, Lordship, is page 123, Lordship. Sorry, 123. Submitted a report.
One.
Lordship, it is 123, Lordship. 123, Lordship. On 7/8/2019, Lordship. Found that the petitioner's institution fulfill all the criteria. And that, Lordship, with all respect, I must clarify, Lordship. Since 2019, Lordship, till date, the Pharmacy Council of India, Lordship, continued their approval after proper inspection, Lordship. The state is not only a formality, Lordship. But in spite of that, Lordship, they are subsequently, by virtue of this honorable court's order, they make an inspection, Lordship, and found that petitioner's institution did not fulfill that, which is only a mere formality, Lordship. Once the PCI, Pharmacy Council of India, is the head, Lordship, who has given approval till since the 2019 to till date, Lordship. And
But NOC is required or not?
only say that also not, Lordship, that they are saying that as per their policy decision, and some of the judgment of the honorable apex court says that NOC part, Lordship.
Yeah, Google.
My lord will kindly have a look at the impure order.
No, that,
Yes, my lord, in the meantime, during the pendency of the writ petition, the new policy came into force of it's part of but I have given a copy of a notification of 7th of November 2023. By this particular policy of the government, my lord, all, my lord, pharmacy institutions are supposed to, my lord, apply for NOC. And the detailed procedure has been laid down in para in the second phase. Second phase, my lord, Roman 2. So I place this before the honorable single judge. And my lord, honorable single judge, therefore, my lord, since this has not been put to challenge or he has applied pursuant to this policy, has finally, my lord, dismissed those writ petition, entire beds of writ petition. And lordship will see, my lord, the final order. Liberty has been given to them, my lord.
Page para 23.
Yes, ma'am. Not, yes, 23. And the reason for dismissing is there, my lord, at para 20. 20 and 21. 20, 21, 22 also, my lord.
My lord,
Okay, this will make it. I don't think there's any limit. Either they apply or challenge it, my lord. It's up to them, my lord. Without that, my lord, assume that my lord, the policy is changed.
So
They
this
have
is
every right to challenge it, my lord.
this policy is holding the field.
Yes, my lord. Maybe it is not, my lord, as per the law. Maybe, say, my lord, they can plead that. But today they will have to challenge it, my lord. And lordship will see, my lord. In fact, my lord, one thing is very serious, my lord. In page 117, the Pharmacy Council gives the affiliation. There are certain conditions. So far as, my lord, diploma is concerned, my lord, one lordship point A and B at the top. No admission shall be made without submission of consent of affiliation of the examining authority to PCI. Now, my lord, they don't have this, my lord, affiliation of the examining authority. Yet they want to, my lord, they are probably they are continuing with the, my lord, course. This is very serious, man. The examining authority.
There is no such course. I am clarifying. No course, no
That
admission
part-
till date,
Yes,
lordship, because
that
we are
way
fighting
it's
in the court, lordship.
That is
Because
fine. And NOC, my lord, it is
NOC,
it is the, my lord, Pharmacy Council, you will see, my lord, regarding B firm. It says the above approval is subject to the submission of consent of affiliation of the examining authority and NOC/approval of the state government for starting the B firm. So, my lord, the affiliating authority, the apex body in, my lord, central body, that is the Pharmacy Council of India, they have sought for the NOC, my lord. Yet they say that, my lord, it's not required. In fact, my lord, challenging this particular requirement of the, my lord, Pharmacy Council of India, a matter is pending for the division bench. They've challenged that also, same petitioner institution. No, my lord, that this particular policy that, my lord, they will have to have the NOC from the government for.
This 117.
Not 117, my lord, there is a, my lord, particular regulation of the, my lord, Pharmacy Council of India. Particular clause in law.
That is under challenge.
It is under challenge before the division bench. So, until and unless though that case is decided, whether, my lord, they can now, my lord, pursue this petition. Otherwise also, same petition happens. And lying before the division bench.
Yes, Majumdar.
But council is different, but, my lord, I have appeared, my lord, in that case too, that's why I know.
regarding the notification, my learned friend is saying, as per Pharmacy Act, lordship, that notification cannot be as per section 46.
Challenge it, my lord.
So, lordship. Oh, lordship, it's a state, lordship, the state have no such power, lordship, to stop the petitioner's instruction. Only a mere formality like a lawful lordship, bar council is making inspection, lordship. And apart from that, lordship, there are the some of the judgments also the honorable apex court lordship will allow over that.
Para 22 and 23, you have been given sufficient liberty. One, you have been given the liberty to challenge the notification.
Actually, lordship,
Number
the
para 23, if you apply in terms of this policy,
my
then
respect. Sorry, my
Yes.
respect to submission, once they found my institution is in order, lordship, NOC was recommended by the letter in 2019 by virtue of this honorable court order. Subsequently, their lordship, they will never, with all fairness, I am submitting, before they will never accept my institution, lordship. So I leave it to your lordship to decide either issue notice.
My lord, the inspection was conducted pursuant to order of this honorable.
I admit that.
Whatever are the shortcomings, my lord, it has been pointed out in the report. They could have by now, my lord. Almost 2 years have passed, my lord.
Lordship.
They would have corrected it, applied fresh, my lord. Then, my lord, they could have got the NOC.
Because while
It
I
was pointed out. And they are challenging that, my lord. They want that, my lord. There are no proper faculty also, my lord. That is one ground, my lord, for rejection of NOC.
then how the
Whether
earlier
that can be
lordship
allowed.
in 2019 lordship, I have referred this letter, lordship. In terms of that lordship, my institution was found in order, lordship. Page, just I'm coming, lordship. I have just now referred. Page 52 also, one letter is there, lordship, and also in 2017 also, lordship, there was a, they found my institution is in order.
Majumdar were not impressed.
Lordship,
We'll close this writ appeal.
Lordship, I leave it to with all respect, Lordship, whatever. Kindly pass.
Dismiss.
Item 14. May it please, your lordship.
Hmm.
My lord, I have received in this appeal, my lord, order passed by Honorable Single Judge, my lord, dismissing my writ petition, which was numbered as 6390, my lord. Basic claim of the petitioner in the writ petition was that some VRS benefits, my lord. There are two prayers, my lord. In one, the petitioner claiming the VRS benefits up to the date of closure of the mill. The appellant union is the union of ex-employees of Assam Cooperatives Spinning Mill Limited. For the benefit of the members, my lord, the union has filed a writ petition. In another prayer, my lord, the petitioner is claiming the house rent allowance and medical allowances, which has already been granted long back, my lord, in the year 2014, my lord, in state fed case, my lord, to the similarly situated persons, my lord. And the honorable court, my lord, held that, my lord, in para 12 at page 62, my lord, in the order that once the employees accept the VRS proposal of the scheme and the same is accorded approval by the appropriate department, the employees are bound by the term and conditions specified in the VRS scheme. The closure date of the mill, as notified by the department, will not bear any consequence without reference to the terms and conditions specified in the VRS scheme proposal, which are not before the court. But, my lord, that the scheme, the petitioner has not incorporated with the petition, but the respondent has furnished it along with its affidavit in opposition, my lord. The scheme is in the record, my lord, case record. My lord,
Who respondents are not there?
my lord, Cooperative Society is the main respondent here, my lord. My lord, the learned standing counsel informed over telephone me that he has some suffering, my lord. His junior have to appear, but now no one appeared, my lord.
Okay. Heard Mr. M. Saike,
Thank you, my lord.
learned counsel for the appellate. Who's the standing counsel, the cooperative department?
G. Bodole, my lord.
On request made on behalf of MS, Mr. G. Bortolo, learned standing counsel, cooperation department, huh? List after the summer vacation.
Item 4.
Oh, one more is there. Have you found him?
No, Lordship.
Could you talk to him?
I have served him on 8/5, but no objection they have filed, but today one name is shown. Counsel.
A Gundu or something, one
Yes.
Gundu is there.
His name is shown. I have served on SNAT. Yes. But Kundu's name was also there in the writ petition. Yes. Now I have served to him only.
You have served or not?
Yes, or not.
You have for item 4?
No, you're not. Item 14.
Okay. 14 is over. After the summer vacation, we'll have third MS B. Sharma Leonard, CGS for the applicant. None appears on behalf of the
Respond.
opposite respondent number 1, isn't it?
Yes.
Oblique writ petitioner. Stop list after the summer vacation,
Showing the name of S. Nath Lordship.
showing the name of Mr. S. Nutt as the learned counsel, appearing for the opposite party number 1. Huh?